Imagine, if you will, a couple coming together and had this wonderful experience of making a family and going to the hospital and having a baby, and everybody's happy at the beginning and everybody's joyful, and then they just let that baby alone. Then they stop taking care of it, they start nurturing it, and basically the baby just dies. Now that's kind of a gruesome way to start a presentation. I don't want to be starting out as a downer. But unfortunately, a lot of people do that with their businesses. A lot of people don't understand that a business is an entity. A business is a separate legal entity, which means it is a legal person under the law. And so when you set up a business, you actually give birth to a legal person. You just ignore what it takes to maintain that business and to keep it looking like the business you intended it to be, then it begins to die as a separate entity. And what I'm talking about is what is known in the legal field as the alter ego doctrine. The alter ego doctrine is when you think you've set up something else, but you treat it as if it's you. You give birth to a separate legal entity, a corporation. You set up a corporation, but then you don't treat it as a corporation. If you don't treat it as a corporation, and you treat it as just an extension of yourself, then what happens is a judge is going to do exactly what you do. I mean, he's going to call a duck a duck. If he looks at your business entity and it looks like you, it talks like you, there are so many unified aspects between your business and you personally that it just looks like an extension of you, then that's exactly what the judge is going to do. Okay? Now, the alter ego doctrine goes way back. In the state of Nevada, it was first adopted in a case called McCleary Cattle versus Sewell, and it's in the article. If you want to go see the article, it gets more detailed. The alter ego doctrine was adopted in that seminal case, and through that doctrine, you can pierce the corporate veil. That's a phrase that you've probably heard. You set up a corporation to separate the corporate assets from your personal assets. And if your corporation does something negligent, you don't want the people who sue the business to come after your personal assets. Similarly, if you own a business and you do something personally negligent, you don't want the person who sues you personally to be able to get the assets of the business. And so you try to separate those. And you separate those by maintaining the corporate formalities that are necessary to show a judge that this business is not me personally. I may be involved with it, but this is not me. This is me, this is my business. And we treat this as a separate business. So, the alter ego doctrine was adopted by statute in the state of Nevada in NRS 78.747. And this is what it says. I don't like doing long legal quotes in a presentation, but this is black letter law, so it's good to bring it out. This is what NRS 78.747 says, .747. This is what it says. Except as otherwise provided by specific statute, no stockholder, director, or officer of a corporation is individually liable for the debt or liability of the corporation unless the stockholder, director, or officer acts as the alter ego of the corporation. Number 2, a stockholder, director, or officer acts as an alter ego of the corporation if, and then it gives 3 factors. So in Section 1, basically, just to recap, Section 1 says you will have protection personally. You can't be held personally responsible for the debts or liability of the corporation if you maintain a separate entity and maintain enough of the separation that the alter ego doctrine does not apply. And then in subsection 2, which I'm about to read, it tells you what the courts will look for to determine whether or not you have sufficiently separated yourself from your corporation, or whether or not that alter ego doctrine should apply to you. And this is what they look like. This is what they look for in subsection 2. A stockholder, director, or officer acts as an alter ego of a corporation if 1. The corporation is influenced and governed by the stockholder, director, or officer. That means the person you're trying to get after has control over that company. They have the ability to make decisions for it, and so whoever they're trying to go after through the alter ego doctrine has to be the decision maker. Has to be somebody who actually has the authority to direct the course of that particular company. Now that's only one aspect. Subsection B of section 2 gives us the second prong of this test. Quote, there is such unity of interest and ownership that the corporation and the stockholder, director or officer, are inseparable from each other. Quote, semicolon, and then here's the final prong, C, adherence to the corporate fiction of a separate entity would sanction fraud or promote manifest injustice. So there's the three prongs. One, you have to have control. If you want to go after somebody as the alter ego, they have to have control of the company. Two, there has to be a unity of interest, and we'll talk more about that in just a minute. But basically, they have to be one and the same. And three, it has to result in an injustice for you not to go after that individual. All right, there's no litmus test regarding this. It'll be an overall thing that the judge looks at. One prong's not enough. He'll look at all the evidence that is presented to him overall before he decides whether or not to apply the alter ego and doctrine and allow you to go after an owner or operator of a business. Now, part of the reason we came together today is to talk about what we can do at the end of the year. In the law, we don't have any end-of-the-year things, not like accountants do. But we do have something that I like to do yearly. For all of my clients, I have them look at their business on a yearly basis. It can be the end of the year if that's when you really do your analysis of your business. Most of my businesses will do it at the anniversary of their incorporation. The reason is because I send them a reminder at the anniversary of their incorporation that they need to renew their corporate status. They need to contact the Secretary of State, they need to pay their yearly fees, and they need to renew with the Secretary of State to make sure that their status does not go into default or worse yet, revocation. Now when we do that, when we remind them that we need to do that renewal, we also send them a questionnaire and we say, have you done this? Have you done this? Have you done this? And have you done this? That is a list of formalities, corporate formalities that we want all our corporations to do to make sure their veil is strong and cannot be pierced, to make sure the alter ego doctrine will not apply in my client's situation. So this is what we make sure that all of our clients do. And right now I'm just going to limit it to corporations. I'll talk a little bit about limited liability companies in a minute, but what I say now is particularly about corporations. You need to have a shareholder meeting. And not only that, you need to have a board of directors meeting. And this is really confusing to a lot of people. They don't understand the difference between shareholders or board members or officers. If you have a corporation, you have shareholders, board members, and officers. And they're not all the same people, although in small corporations, they're often the same people. But you need to understand which hat you're wearing. The shareholder is the one that owns the business. The shareholders own the business. And they should have stocks and bonds issued to them. And that's one of the things on our list. First of all, when you first incorporated, did you have a shareholder meeting? Did the people who own it receive actual hands-on certificates for their stock? And that's a formality we want our people to do. Did you get stock? Did you get actual physical stock certificates indicating that you are indeed a shareholder? Now, if you're a shareholder, then you have a right to elect the board of directors. Did you have a meeting where you elected the board of directors? And once you elect your board of directors, did you have a meeting of the board of directors to elect your corporate officers? Now, when you've got a small company where you got maybe 3 people at the most, they don't understand how this works. They're like, I got to have 3 meetings? Yeah, you can have them right after the other if you want to. But you as a shareholder have to elect yourself to the board of directors and then elect yourself president of the company. And you need to have writing of each of those. You need to have corporate minutes where you say, this is the day we met, this is what we decided, and here's the people that were at the meeting, and have it signed off by the secretary, which just happens to be the president. Because I've seen a lot of corporations where the president, vice president, secretary, they're all the same people. And if that's the way, if you're really that small, okay, well, I'll work with that. But you have to do the formalities so that you can go into the court and you can say, Judge, what are you talking about? The alter ego shouldn't be here. I was a shareholder and I elected myself the board of directors, and I elected myself to the president of the company, and here's all the paperwork. So I'm doing this effort so that this wouldn't happen, so that the law will protect me from exactly what this plaintiff is trying to do to me. So that's what we're trying to put together. All right. So you need a board of directors meetings. You need to keep the corporate minutes to go along with it. You need to have corporate bylaws. Now, they're not required in the state of Nevada, but that doesn't mean you shouldn't have them. Okay? Everybody should have corporate bylaws. That is a document that says how your corporation is governed. And if you go to the effort to do corporate bylaws, that's just more paperwork you can show the judge that says, look, no, I'm serious about this separate business. We sat down, we figured out what the rules of the business were going to be, we put it down in writing, we signed it on this date, we had a meeting about it, and it shows the judge that you are really having a separate business and treating it like a business. Oh, I see this one a lot. If you set up a business and you enter into a contract, do not just sign your name to a contract. Whenever you represent your company, you need to think to yourself, I am acting as the president of this company when you enter into a specific contract. And what you have to say to yourself is, Dave Salmon's not signing this contract. Dave Salmon, president of David Salmon and Associates, is signing this contract. And you have to sign your contract. Your name, president or vice president or whatever your corporate office is. You put a comma after your name and then you put what your position is. So that later on when a breach of contract comes, big breach of contract case comes, you can hold that contract up and say, I am not personally liable for this contract. I put it right here that I was acting on behalf of the company. Oh, and by the way, don't allow them to slip your personal name into the contract. That contract should be with your company, and make sure it says company. Because if they put company, your name, you're personally liable for that contract. You don't want them to let them do that. And also be very careful about personal guarantees. They'll stick them on the back of the contract, and they'll just say, oh, and sign this too. You have to know what a personal guarantee is. Because basically you're doing away with your corporate position if you sign a personal guarantee. You're saying if my business doesn't fulfill this contract, I'll fulfill it personally. So you're defeating the purpose of trying to keep that separation. Now, some contracts you're not going to be able to get away with without doing it. Banks don't want to do business with your business. Now, without a personal guarantee, you may not be able to get a loan if you don't do it. So you'll have to decide whether or not this contract is important enough for you to put your personal assets on the line for it. Okay? But you should at least know what you're doing when you do it, because there's a lot of people that sign documents that don't know what they're doing and end up with problems because of that. If you set up a business, you must have a separate bank account. I can't tell you how important this is. It seems like it's just common sense, but we see it a lot where people are not putting up separate accounts. I see it mostly when you have more than one business. People will put together more than one business and then they'll use one bank account for multiple businesses. You're defeating the purpose of the asset protection if you treat three businesses as if it was one business, because the alter ego doctrine can also apply, not just between an owner and the business, but between multiple businesses. If you treat three separate businesses as actually one business, having one account, the judge will treat your three businesses as one business. And you may have debts here, and he'll take into this other company, to satisfy the debts of this other business. The alter ego doctrine applies to multiple businesses, as well as businesses and individuals. File taxes. That's like Business 101. You don't file taxes, you're going to get in trouble with the IRS, and I send you to a different attorney for that one, because that's criminal. You get in that's when your business goes into criminal law, and I'll send you to a criminal attorney if you don't pay your taxes, okay? Because that can get to be a real mess. Create contracts. I see this a lot. I always advise my clients, don't take loans from your business. Because if you got money going back and forth from you to your business and from the business to you, that's just an argument that you're one and the same. So I don't like business owners taking loans out from their business. But if you're going to do it, make sure there's a loan document. Because I see a lot of business owners that just take money out of their business and then put it back. And then they try to put it back. And there's money coming out and money going in. That just strengthens an alter ego alter ego argument. Make sure that if you're going to take money out of your business on a loan basis, that you have loan documents. Now, some business owners will take money out, put money in, and I can't tell what type of transaction that was. That's also a real problem. There's bookkeeping problems. And every business, by the way, needs an accountant. Because the accountant should help you understand what was the nature of this money. Did you take this money out as a loan to you personally? Was this money taken out as a draw? Was this money taken out as a salary? And if you don't know the differences between those terms, you need to talk to an accountant because you're going to get yourself in trouble. And so, I, as an attorney, a business attorney, when I look at the history of a company, if I can't determine what the nature of a transaction was, a business transaction, whether it was a loan, whether it was a draw, whether it was a salary, whether it was a payment on a contract, if we can't determine that, I got to tell you that judges have a very small level of patience for that. And what I mean by that, they're just going to throw it out. They're just going to say, okay, I'm not dealing with that. I'm not going to try to determine this. We're just going to call it what I want to call it. And so basically what I'm saying with this is you have to make your business look like a separate business. Keep it different than yourself and make your business look like what you want a judge to treat it as. Not just for your business, that's for individual transactions as well. Make each transaction look like what you want it to be treated as by a judge. And the way that you do that is to have proper documentation. If you're going to take money out, you need some type of documentation indicating what type of withdrawal that was. Same thing with putting money into your business. You need to know what the phrase capital contribution means. And if you don't, you talk to your accountant. Because you need to know what money goes into your business and comes out of your business. Capital contribution is money from you into your business. And that needs to be properly recorded in your account, in your books, and your accountant can help you with that. But you want to make sure you have a proper foundation in paperwork, in bookkeeping, so that it's easy to see what type of business you have and what the nature of the transactions in that business are. Okay, and finally I'm going to talk about have active corporate officers. Oftentimes I see one person running the business and he has his wife as vice president. When you form a company, corporate officers have what they call fiduciary duties, which means you have a duty to know what's going on in the business, to actually vote in your business, and to be actively involved. There's actually case law about this, where there was a member of the board of directors who was just there, and maybe she went to the meetings and maybe she didn't, but she was totally in the dark that the other board members were committing crimes. And the court held, look, you had a responsibility to know what your board was doing. Now, they kept you in the dark, and you may not have been involved in the crimes, but you have to know what they're doing. You have an obligation to be involved and to know what's going on and to participate, to be active. And a lot of people don't know that. They just like being vice president, but they don't want to do anything about it. They don't want to be part of the decision-making process. They don't want to go to meetings. That's not the best approach, because you have responsibilities to be active if you're going to take on the responsibility. Oh, and by the way, somebody may come up to you and say, we're so pleased with you and so impressed with you, we'd like you to sit on our board of directors. That's an honor, and that's going to puff you up. That's going to make you feel, great. And I've been approached by businesses who want me to sit on their board of directors. But I know that comes with responsibilities. So I'm not going to sit on a board unless I'm going to really be on the board, unless I'm going to be involved, unless I can see the books, and I will look at the books, and I will make sure that the other board members are doing what they're supposed to, and I am going to be watching what the president, the vice president, and the other corporate officers are doing. because I know that sitting on that board brings fiduciary responsibilities. So, those are the corporate formalities that you need to do in order to make sure that your veil is strong and impenetrable. Now let's talk a moment about limited liability companies. Everything that I said about corporations, I equally believe are applicable to limited liability companies. Now, if I was an attorney, I got hired by a limited liability company, and this owner had done everything wrong, I would go into court and I would say, Judge, really the corporate formalities for a corporation don't really apply to limited liability companies. There's no statute in the limited liability statute for limited liability companies like there is in the corporate statute. There's nothing similar. One of the reasons that limited liabilities were created was to get rid of some of these formalities, to get rid of the need for a shareholder to elect himself a board member and then to elect himself the president. So in limited liability companies, we're trying to do away with a lot of that. Now, that's the argument I would make if I was representing that person. But if I'm advising you as a new business owner, I'm going to tell you, do all the corporate formalities. I don't care if you're an LLC. Do them all. To keep me from having to make that argument on your behalf in front of the judge. If you've got all the corporate formalities, I don't have to make that argument for you because we've already just complied with it. So I do recommend that all those formalities be complied with on limited liabilities companies as well. If you do that, your baby will be healthy, your veil will be strong, and the asset protection you tried to put in place when you formulated your company will be there, and all will be well. Thank you. Any questions?
Okay, so this might be a little bit of a stupid question, but I'm sure that you get a lot of stupid questions, so you're ready for this.
I've never called him that.
Oh, I will.
Okay.
So say I have 3 companies, right?
Mm-hmm.
And each of them has their own bank because that's the right thing to do.
Okay.
And there's notes for every time I use some of them, some of the money from my first company, right?
Okay.
So do I have to do the same thing with my own bank or myself?
Maybe I don't understand the question, but you're not a corporation, so you don't have to do corporate formalities for you personally. I mean, you're not president of your house,
Right.
so you don't have to have, corporate meetings with you and your wife or your children. So no for that.
Okay.
I would keep my personal books separate. I would keep books, by the way. And whether it's QuickBooks or Quicken, I'd have to do Quicken for personal. That way, because there's no downside to that. It just shows you got your business together. So that's my answer to that. For home, no. For you personally, no. You don't need to do all these. This is just to keep your corporate veil strong, just to maintain your business as it should.
Okay.
Any other questions?
So Damien, who's operating his Rocket Fizz store, should do all these formalities.
What type of business are you?
I actually have a limited liability company because I do have a partner,
Okay.
and we have an operating agreement, which we structured in the beginning. And our operating agreement is a 20-year operating agreement. So once that finalizes, then we sit down and we can do another one. But right now, we don't really use formalities because we've already structured all that in the beginning when we first opened. And we have a chain partnership since then.
I would still do corporate minutes. I've been an LLC right now. I'm an S corporation. I would still do corporate minutes. I would still build yourself a defense to a lawsuit.
Okay.
Imagine what will happen if you have a lawsuit. So even though the law may not require you doing the corporate minutes, and it doesn't, although it may not require you to do all the things that I've said, I would do as many of those as you can put in there.
So for example, if like I just got a new vendor this last week, that should be a formality because I'm actually staking money and I'm spending money, our money, my partner and I's money to buy this new vendor.
Yeah.
So that should be a formality to incorporate that into my business model, right?
Right.
Okay.
And there's different levels of formalities too. I mean, if you've got a big company with 1,000 shareholders, they have to do a formal meeting with a formal notice, and they meet on a certain date, and they vote on a certain date. You don't have to do that with a small company. If it's nothing more than you and your partner talked about a new contract, just have your secretary or somebody just jot that down. The date we met and we talked about this, we decided we're going to go for this contract. That's a corporate minute. Resolved, and there's forms you can get online. Just do something that says, on this date we got together, and we decided this is what we're going to do. Sign off on it, put it in a book. So that, one, that helps you. I mean, it helps see the progress of your company, and it helps tell the judge, no, we met. It's not me just running everything. Because, by the way, you may have a partnership dispute someday.
Yeah.
And that's going to show, well, we made this decision together, Judge. And here's the date we talked about it. Here's the decision we made. So it's just, I would always write down the major decisions that you make, whether they're major clients, major contracts, new direction for your company. I just do a quick minute, corporate minute, anytime we just do anything major. Any other questions?
So if somebody walks in Damien's store, slips and falls, would he need to have this separate, this veil? Could they sue not only the store, but also Damien for all he owns?
Yeah, and they will. What I'm telling you, by the way, is to lay the foundation for a legal argument. I have no doubt that a good plaintiff's attorney is going to sue both of you. And he's going to make that alter ego argument.
I also have $1 million insurance policy too. To cover
Yeah,
this
and that's something I didn't talk about. But really, a good insurance policy is just like a fat steak for dogs. And if they're coming after you, you take that insurance policy and you throw it out at them, and they will run right after it. Because they don't want to come after you personally. That's a hassle. They would much rather go after an insurance policy. So that's something I hadn't mentioned, but that's very important. And a lot of attorneys, the insurance policy may not cover all the damages. They may have damages in excess of your policy limits. But a lot of attorneys, they won't go after the excess. They'll just limit it to the policy limits just to get the case done. So a good insurance policies are very important. I'm a very strong advocate of getting a good policy for your business. But they're going to sue you, and they can't maintain a suit against you. As your defense attorney, I would try to pull you out if you didn't personally do something wrong. Now, this is another thing that a lot of people don't understand when it comes to asset protection. If you are a painter and you're painting something, and you may be an incorporated painter, you may have a corporation, but if you're doing the painting and you knock the can off the ladder and it hits somebody in the head, they're going to sue the paint company and they're going to sue you personally because you personally caused the harm. Does that make sense? So they'll sue the company, but they'll also sue you, and a judge is going to let them sue you because you are personally negligent, as well as the company being negligent as well. So none of this is foolproof. No asset protection is foolproof. I don't yank chains. There's a lot of attorneys that do. They sell junk on asset protection. There's no foolproof, but there are things you can do to make things, operate the way they should, because you're making corporations so that if your employee does something wrong, you're not on the hook. If your employee does something negligent, then they may sue the employee, but they'll sue your business. But you personally didn't do anything wrong, so you personally should be on the hook for those debts. And so there's things you can do just to maintain that. And when I talk to businesses when they come in, I actually say, what's the nature of your business? So that I can see where is the risk located within your business. Are you creating the risk personally? If you're creating the risk personally, then you personally can be held responsible. And so what you can actually do in a lot of these, and I'm actually going off my subject, so I'll cut it, make it short and stop this. But what you can actually do is you can take the risk and your assets and separate them. So that you set up a corporation with the assets in it and a separate corporation with the risk in it. Or who's doing the work. So that they sue the negligent party is here, but your major asset is here. Now you see this a lot with real estate. They'll put a building in this business and a management company in this business, because these are the people who hire the painters and the maintenance people, and this is where the risk is at. So if they sue this company might have a few desks and computer, a few bucks in the bank account, but the building itself is over here, and it's protected. Now, remember what I said about the alter ego doctrine? The more those companies intersect, the closer they are, a good plaintiff's attorney is going to try to pierce that because they want the building. Understand? That's why you need to do these corporate formalities, to keep those risks and the assets separate. So there's a lot of things you can do. There's a lot of strategies you can adopt.
Okay, so Christopher's a copywriter. Let's say that he writes something that ends up, he says something politically incorrect or something. It causes damage to a business. That business goes to sue him, that business client of his. How can he protect his personal assets from his copywriting business?
Well, he can't in that situation. Here's the reason why. He's personally defamed. It'll be a defamation case, and he personally defamed. It's not like a breach of contract where the company entered into the contract. If you have a company here and you get into a car accident, you are personally liable for the car accident. Your insurance has to cover you personally, and your liability insurance for your business isn't going to help you. That they don't cover you personally when you're driving your car. So you're going to get sued personally. It's not going to be your business named in that lawsuit. It's going to be your personal name, and your personal assets will be on the line. But the nice thing about the corporate veil is they can't go after your business. Now, this is a whole different, I'll probably have a different seminar on this, because it has to do with what's called a charging order. And I'll let you go look that up. Maybe I'll have a different presentation on it. But the reason a lot of people want to come to Nevada and incorporate, we have the strongest charging order law out there in the entire United States. And it protects business owners. They cannot get your business in the state of Nevada. That may be an overgeneralization, and I don't have time to get into it, but that's one reason why a lot of people want to come to Nevada, is because we have such a strong charging order statute. They can't, even though they have a judgment against you personally, they can't get at the business. And we'll talk about that more later.
Okay, so what you just told David, I just want to make sure that I get this right. I'm a freelancer. As a writer, as a photographer, I'm a freelancer. Does this mean that any time that one of my many bosses wanted to use a law for me, it would be actually for me? Because I'm a freelancer?
Yes, do you freelance under your own personal name? Do you sign contracts with your clients?
Sometimes.
When you do the work? Okay, when you do the work, do you sign your personal name? Or are you listed personally with your name on the contract? Or is the name of the business listed on the contract?
Just for also me.
Yeah, it's you. And are you incorporated anyways? Do you have a corporation?
No, I don't have enough money.
Yeah.
to-
And that's common. That's common, Chris. That's common. So yeah, everything's you. You are what they call a sole proprietor. And when you're a sole proprietor, everything's on the line.
Okay.
There is no separation between you personally and your business.
Right.
You didn't incorporate, and so the alter ego doctrine doesn't even have to apply,
Right.
because there's no alter ego. It's just you. That's all there is you. You doing the work, you entering into the contracts, you taking all the risk, and you having all the assets. It's all you when you're a sole proprietor.
No, thank you.
Any other questions?
Good stuff.
Very good. Thank you, everyone.
Thank you.